Good afternoon. I'm talking from Venezuela. Unfortunately, I could not fly to Toronto today. I hope that you are enjoying this excellent conference. Right now, I will present the main ideas for you to discuss about my paper on the sovereignty state and the protection of human rights, the case of Venezuela and the Inter-American system. To begin with, I will say that the rise of human rights discourse and instruments has significantly challenged the state sovereignty. From 1948, with the adoption of the Universal Declaration of Human Rights, states around the globe agreed to follow an international legal system enforceable either in domestic or international courts. In this sense, Latin American states have ratified their commitment to protect and preserve the principles adopted in the American Convention of Human Rights and the Declaration of the Rights and Duty of Man. The states of the region have amended their constitution and domestic legislation to welcome international agreements, strengthening justice around the hemisphere. This expressly authorized the International American Human Rights System to examine complaints or petitions regarding specific cases of human rights violations. However, a number of scholars predicate their theories of global justice on defending the state sovereignty. For instance, Thomas Nagel states that the international law is only a series of agreements between sovereign states entered into for their mutual benefit, where the international legal rules constitute a false premise of international institutes. There is much to do in the international arena. Therefore, I will defend the international right-based approach in place of defending the state sovereignty. A truly sovereign state bases decision on the will of the people, which cannot be fully expressed without protecting their fundamental human rights. And I am optimistic, as Matthias Reich stated, and I quote, "Global order is not fundamentally unjust, it is incompletely just." That is, that the Inter-American system is not completely just yet. Although the international law is not perfect, the great advantages it has brought are undeniable. As for example, the International Court of Justice, the International Criminal Court, and other regional institutes such as the European Court of Human Rights or the Inter-American Commission and Court of Human Rights. Also, the international treaties and covenants such as the International Covenant of Political and Civil Rights, the treaties in favor of human rights, indigenous, and recent, the Inter-American Charter of Democracy, a small step for a better future in the Americas. Venezuela is a good example of how the international law has served the purpose of promoting justice outside of a sovereign state. In general, Venezuelans are looking for justice in a global scale. This is the case of Piazza, where retired workers of the Venezuelan International Aviation Corporation alleged to the Inter-American Commission of Human Rights that the Venezuelan state was responsible for violating their right to social security, as it is established in Article 17 of the American Declaration of the Rights and Duty of Man, as well as the right to judicial protection, Article 25 of the American Convention of Human Rights. After examining the arguments and evidence of each party, the Inter-American Commission concluded that the case was admissible, allowing the Commission to open a procedure for a friendly settlement that ended with both parties signing an agreement where the retired workers receive their adequate payment of their pension and compensation for moral and material injury. This is one example of many successful cases that ended with just result. More and more cases are followed through the Inter-American system. Venezuelans are now struggling to express freely, and the Inter-American system has provided tools to find justice outside of their jurisdiction. Cases such as Luisana Rios from RCTV, Gabriela Peroso from Globovisión, and Marta Colomina from Televen, among others, have found in the Inter-American Court precautionary measures requiring the state to adopt effective actions to respect the right to freedom of expression in a democratic state. International human rights law has evolved to a point where the state immunity is gradually dismissed, especially when the state violates or deviates from the expected standard of conduct adherence to by all democratic nations. As author Ian Pellet stated, and I quote, "In cases of human rights violations, sovereignty is never a defense. In cases of gross violations of human rights, state sovereignty has no role to play, and it does not impede the Inter-American Court or the Security Council of the United Nations from concluding that such violations create a threat to draw the appropriate legal consequences." The end of the quote. To conclude, as Immanuel Kant in Perpetual Peace, 1876, suggests, to create a lasting peace in the world, we must rule a cosmopolitan law, where individuals have rights as citizens of the earth rather than as citizens of a particular state. Thank you for giving me the chance to make this short presentation. Should you have any question or comment, please do not hesitate to contact me. Thank you very much.